Hello guys, through this video I want to discuss with you this concept called circulation of members resolution, section 111. Circulation of members resolutions, section 111. It's a very interesting concept. Listen carefully. So here what happens is, let us say there is a group of shareholders, okay, and there is a company. This company is going to hold a general meeting. Now, in this general meeting, what are the matters that will be discussed? All those matters the company will list down in the notice, right? And all those matters are decided by whom? By the board generally. So, whenever the company wants to hold a general meeting, the company decides, the board of directors decide what are the matters that will be discussed in the meeting. But don't you think there is a possibility that even the shareholders may have some ideas? Even the shareholders may want some discussions to be made in the company's general meeting. Even the shareholders may want some resolutions to be passed in the general meeting. So, to give effect to that, this section has been introduced. Section 111 gives a power to shareholders. Which shareholders? Shareholders who are holding at least 1/10 of the total voting power, or shareholders who are holding at least 1/10 of the paid up share capital, as the case may be. These shareholders can give a notice to the company, either requesting the company that we want to pass a resolution in the general meeting, or requesting the company that there is a certain matter, about this matter we want to have a discussion. So two types of notices are possible. Either it can be a notice for a resolution, either a notice saying we want to pass a certain resolution, or a notice saying that there is a certain matter and I want to discuss that matter in the shareholders meeting. So the shareholders will send this notice to the company. And why is this concept called circulation? Because now the company will send a copy of that notice to all the other shareholders of the company. Okay, so this, I'll repeat again, this group of shareholders who are holding 1/10 of the voting power, or at least 1/10 of the paid up share capital in the company, they want to take initiative, they want to discuss a certain matter in the company's meeting, or they want to pass a certain resolution in the company's shareholder meeting, and they will give a notice, a written notice they will give to the company, and the company will then circulate the notice to the other shareholders. When these shareholders give this written notice to the company, along with the written notice, they must also give a certain sum of money which will help the company circulate this notice to other shareholders. I'll repeat again, whatever expense the company will incur in circulating the notice to the other shareholders, that expense has to be given by the shareholders to the company. A sum of money has to be given by the shareholders to the company to help this company meet this expense. Okay, now what's the time limit? When should this notice be given to the company? It depends upon the notice is for passing a resolution, or is the notice just to discuss a matter. If it is to pass a resolution, we will see when is the general meeting going to be held. Before that, leave 6 weeks. Even before 6 weeks, the shareholders should have sent this notice to the company along with a sum of money. But if it is to discuss any other matter, in that case, we will see when is the general meeting. Before the general meeting, leave 2 weeks. Even before 2 weeks, the shareholders should have sent this notice to the company. Okay. So for resolution, the shareholders should have sent the notice to the company at least 6 weeks before the meeting. And for any other matter, the shareholders should have sent to the company the written notice at least 2 weeks before the meeting. Okay, now listen, a problem may arise. Let us say today is the 1st of August, and as on today, the company has not even declared when the general meeting is going to be held. Company has not even called the meeting till now. On 1st August, I give a notice to the company telling the company that company, I want to pass a certain resolution. Okay, then what happens is on the very next day, on the 2nd of August, the company calls the meeting. The company says the meeting is going to be held on 26th August, let us say. So what has happened now? When did I give the notice to the company? Only on 1st of August. Okay. And when is the meeting going to be held? On the 26th of August. Now, in between these two dates, do you have 6 weeks time? You do not have 6 weeks time, but it is okay. The notice will still be valid. I'll tell you why. This example over here talks about a very specific situation where the shareholders have given a notice to the company even before the company could have called the meeting. Even before the company called the meeting. When did the company call the meeting? When did the company give the notice of the meeting? Only on 2nd of August. Only on 2nd of August, company declared it going to hold the meeting. So even before 2nd of August, I have given a notice to the company saying, company, whenever you hold the meeting, in that meeting, I want to pass this particular resolution. I have given this notice on 1st of August, even before the 2nd of August. So the shareholder has given a notice to the company even before the company could have called the meeting. In that case, the 6 weeks criteria, the 2 weeks criteria and all become irrelevant. Okay, understood? If the shareholder has given the notice to the company even before the company could have called the meeting, even before the company could have called the meeting, even before that, if the shareholder gave a notice to the company, we will assume that the 6 weeks and 2 weeks criteria has been fulfilled. Even though the time gap is actually less than 6 weeks, it doesn't matter. The notice will still be valid because the notice was given even before the company could have called the meeting. All right. Now listen, there is one more point. Over here, the company need not send the notice to the other shareholders. Company need not send it to the other shareholders if the company is able to prove to the central government that these shareholders, they have abused their power. If the company is able to prove to the central government that these shareholders have given this notice only for needless publicity, or if the company is able to prove to the central government that these shareholders have given this notice only to defame the company, and in other words, the shareholders are abusing this power which section 111 has given to them. This notice is given to the company only to defame the company, insult the company, only to secure needless publicity. If the company is able to prove this to the central government by filing an application to the central government, then the central government will pass an order saying, okay, company, you need not send the notice to the other shareholders. All right, the central government has delegated this power to the regional director. This is the entire section 111. So giving you a summary now, look at this diagram over here. Section 111 is nothing but a case where a group of shareholders who are holding 1/10 of the paid up share capital or total voting power, they send a written request, they send a notice to the company along with a sum of money. When do they send it? At least 6 weeks before the meeting or 2 weeks before the meeting. 6 weeks before the meeting if they want to pass a resolution. 2 weeks before the meeting only if they want to only discuss a certain matter. Okay, then the company will then circulate a copy of that notice to all the other shareholders of the company. Then we discussed for this circulation, whatever expenses will be incurred. For helping the company meet those expenses, these shareholders will also deposit a sum of money with the company. Then we discussed a very special scenario over here where even before the company could have called the meeting, the shareholder made a notice, gave a notice to the company. In such case, the 6 weeks, 2 weeks criteria become irrelevant. And finally, we learned if the company is able to prove to the central government that these shareholders have given this notice only to secure needless publicity, only to defame a particular group of shareholders, only to defame the company, then the central government will pass an order saying that the company need not send the notice to the other shareholders. Alright, so that is it with this discussion on section 111. I hope you guys understood it.